All right, now let's talk about the bills that passed. Again, I'm not going to go into great detail, but these are just bills that passed that directly impact residential rentals. AB 838 code enforcement. Apparently what was happening is some agencies like Los Angeles County, for example, their housing enforcement, I'm making this up, they weren't doing this, but I'm just using them as an example. Los Angeles County Housing, where a tenant would complain about a habitability issue, sometimes the administrative agency would have a bunch of criteria that they would have to meet, the tenant would have to meet prior to the agency investigating the complaint. So maybe one of those criteria was, well, your rent has to be paid in full before we'll investigate any habitability claim. That has been removed. You can't do that anymore under this law. And under this law, it actually puts an affirmative obligation on the administrative agency to go investigate housing violations. AB 1177 Cal Account Bank Program. This one's really interesting. It'll give you an idea of where we're going, or at least an idea of where a direction we're starting to go. This one will be providing banking services for anybody who is alleged to be outside of your normal banking relationship. So it's claimed right now that approximately 5% of Californians do not have a traditional bank account. So for example, one demographic that's often cited is illegal aliens have no traditional bank account. Technically, that's not true because the large banks, like Bank of America, for example, have specific programs targeted at those people to get them to have the bank accounts or to facilitate that bank account. But the tenants' rights advocates claim that that group of people are still intimidated and they're scared that they're going to be deported, so they don't go to the bank. So what California did was they created this Cal Account Bank Program that will pay landlords both the security deposit and, if necessary, rent. And if this gets implemented, or I should say when it gets implemented, the landlord will not have a choice. They will have to accept rent and the security deposit from this Cal Account Bank Program. So what we're seeing is the state of California stepping into a traditional banking institution role to facilitate this 5%. So that's really interesting. To the best of my knowledge, it's the first time I've ever heard of a state taking on a institutionalized banking role. AB 468, emotional support animals. I actually like this law, but I think it's a little bit half-baked. And what I mean by that is the law now says that before a physician can write a note to a landlord saying, hey, this person requires an emotional support animal, the physician has to have had an ongoing relationship with the tenant for 30 days or more, and they have to have had an in-person meeting with the tenant to make that determination. So what they got right was it's an attempt to shut down these internet websites where you pay $45 and some MD somewhere, in the Bahamas or something, writes you a note that says, hey, oh yeah, Kris German is disabled and needs an emotional support animal. What they got wrong with the law is it only targets licensed physicians. And the law does not require the note come from a licensed physician. What the law says, it can come from anybody who's in a position of authority to know that that person would benefit from the emotional support animal. So technically, my wife could write that note. So it got it halfway right. It hasn't plugged all of the holes yet, but it is a step in the right direction. We've got SB 60, which is a short-term rental law, another law that's really great intentions behind it, unless you're an Airbnb operator, in which case it's a terrible law. But essentially what this law allows is fines of $5,000 every time somebody is using their residential apartment as an Airbnb. And that goes back to your question before about what's a slam dunk case. It's interesting. We have a situation with the city of Santa Monica right now where an individual moved out of their apartment during COVID, and they claimed that they had to move out because of COVID. But what they did was they turned their apartment into an Airbnb. And under the Santa Monica Moratorium and the LA County Moratorium, you cannot evict people for unauthorized occupants. And so the city attorney for Santa Monica reached out to us and said, hey, what are you doing? You're trying to evict this guy. He's got unauthorized occupants. So we came back to them and said, hey, look, it's an unauthorized occupant is somebody who's living with you. It's a little bit different than you moving away entirely and using your apartment as Airbnb and profiting off of it simply because of the moratorium. So that's the kind of case where so far we've asked the city to provide their authority for telling us we don't have the right to move forward with the eviction. And instead of coming back with any authority, the city came back and said, hey, can we do a compromise here? So there is no authority. In other words, if your tenant is currently running their unit as an Airbnb, now's the time to pull the plug and try to evict them on it. We'll move on to AB 491, equal access to the property. That is a Section 8 law. So in other words, what the allegations were that landlords who were taking Section 8 because of the belief now that they have to take Section 8 were trying to relegate the Section 8 tenants to certain areas of the property. For example, they'd say, okay, all we have, because you're on Section 8, all we have is the second floor. And so that has now been made illegal. You cannot relegate anybody who's on any sort of housing subsidy to any sort of area of the property. And moreover, you cannot prevent them from being in any of the common areas of the property. So you can't say, because you're Section 8, you don't get access to the parking garage.
Right.
So again, that's something landlords really need to be aware of, because it does happen. And we'll talk about a little bit more later about the Section 8 aspect of, do you have to take Section 8 or you don't at a later part of this webinar. We've got AB 606, which is a labor law, finding and penalties. And basically what that says is if an employer, so we're talking people who have an on-site manager, for example, the employer is obviously the building owner. If an employer is found to have violations on one property or in one workplace, then they can be found to have, there's a presumption, a rebuttable presumption, but still a presumption that the same violations happen at all of their workplaces. So if you own 10 buildings and you've got 8 on-site managers and you get a violation at one building, you're now presumed to have those same violations at all 10 of your buildings. You can rebut it and overcome it, but the presumption is still there. So it makes it's just a hurdle that's costly to overcome, I'll say. We've got SB 727, which is a contractor's wage and penalties law. Basically, that says that the contractor is responsible for all the subcontractors' employees getting paid. It goes down the line now. So those are that's Section 1 of the bills that passed, and then we're into Section 2 now. And this will wrap it up for the bills that passed. SB 219, cancellation of property tax penalties and costs. This gives the tax collector the flexibility. They don't have to do it, but if a landlord has been negatively impacted by COVID, they can fill out this application, submit it to the tax collector, and if they can establish the impact of COVID, the tax collector has the ability to cancel the tax penalties for late payments. We've got SB 607, which I'll come back to. That's professions and vocations. And candidly, off the top of my head, I don't remember exactly what that law said. So I'll go on to SB 8, extension of the Housing Crisis Act of 2019. Same situation. Actually, these last 3 are important. We're going to see this trend growing. SB 9, duplexes and single family zoning, and SB 10, planning and zoning housing development. What you're starting to see is a upzoning law take effect. So realistically, what's happening in California is housing affordability is going down, and it's getting harder for everybody to afford houses. And so we've got a bunch of single family zoned areas that Sacramento has now said, hey, we have a housing shortage, housing affordability is getting more difficult, but we have a bunch of single family homes people are sitting on. We are now going to allow them to upzone, to turn their single family homes into duplexes, quads. I think it's Senate Bill 10 that allows up to 10 units on a lot right now. And so there's this moving theme or evolving theme of turning the single family neighborhoods into the multifamily properties. SB 8 was the Extension of Housing and Crisis Act of 2019. This law accelerates the approval process for housing projects such as ADUs. So what they're trying to do is they're streamlining the approval process on these ADUs so they can get more housing on the market. And then the SB 607 was we call it a fix to the balcony law. Previously, the balcony inspection law said the individual who inspects the balcony cannot be the same individual who does the work on it. And so a lot of the individual companies that were permitted to do the inspection were saying, we're not going to do it because we can't do the work. And so they fixed that law to say, now whoever does the inspection can also do the work. Now we'll talk about this later, but the inspections aren't due for another 4 or 5 years. So I don't see anybody, there's no benefit, there's no benefit right now to even running out and trying to get it done, because once you do it, the clock starts ticking and it has to be done every 6 years. So if you've got 4 more years, why do it today? But that's what that law is. All right, so we covered all the new laws that will be going into effect. Let's talk about the regulations. So this is what I was talking about before. This is this source of income and the definition of lawful income that has gone into effect now. And what it really means is previously, prior to the passage of this law, a landlord was not allowed to discriminate against an applicant based on their source of income. So as long as it was legal, you had to consider them. Now, Section 8 was specifically carved out of the definition as a source of income. So you didn't have to accept Section 8. If a tenant or an applicant applied to be a tenant, you could say, hey, we don't accept Section 8, and there would be no discrimination. But now Section 8 is included in the definition of lawful income. So if you say, and this ties into that next regulation below it, if you say we don't accept Section 8, you are unintentionally discriminating against somebody based on their source of income, which has now been made illegal. So be very, very careful. Even if you don't accept Section 8, be very careful not to put it in your ads. If you have on-site managers, you need to talk to them and tell them, do not discuss Section 8 with an applicant. If somebody calls you on the phone, candidly, I encourage people who think they're going to be dealing with this to call me and set up a consultation. There are ways around it, but I don't have the time right now, and I don't want to go into it on a video that's going to be put up on the internet, because as I've mentioned many times, the tenants' rights groups watch these videos too. And every time I put a strategy up there, that's the next law that comes out of Sacramento. Right. So if you're dealing with that, or you think you're going to be dealing with that, or you want to talk about how do you build that into your screening process, set up a consultation with me at my office and I'll walk you through it. The discrimination in advertising, it's the same thing. You can't express any sort of illegal preference of any kind in writing. So on your Craigslist or your Zillow ads, you can't say, don't accept Section 8, don't accept animals. You need to be really, really careful what you're wording. And it's one of those situations where less is better. And so if somebody's dealing with that and they want to know how to navigate it legally, set up a consultation with me. Call my office and ask to speak to Cynthia.
So you mentioned animals. So it is illegal to say we don't accept pets?
So you'll notice there's a distinction. I chose the word animals on purpose. Pets, you are allowed to say, I don't take pets. But service animals, including emotional support animals, are not pets. And so you wouldn't want to say we don't take animals. You could say we want pets. We don't take pets. The problem with saying that is it opens the door. So I wouldn't say anything about pets or animals, because you don't want them to question you about it. You can have a no pets policy, that's fine, but keep that to yourself right now. Don't put it in writing, don't put it in your ads. And if you've got on-site managers, then you're concerned about that, you should set up the consultation, and we'll role play some the most common telephone conversations and what you should be saying instead of making costly mistakes.